Justice Thomas, with whom Justice Gorsuch joins, concurring. The court today holds that federal courts may not issue so-called universal injunctions. I agree and join in full. As the court explains, the Judiciary Act of 1789, the statute that authorizes the federal courts to issue equitable remedies, does not permit universal injunctions. It authorizes only those remedies traditionally available in equity, and there is no historical tradition allowing courts to provide relief that extends beyond the parties. That conclusion is dispositive. As I have previously explained, if district courts have any authority to issue universal injunctions, it must come from some specific statutory or constitutional grant. Trump v. Hawaii, 2018. Concurring opinion. But the Judiciary Act is the only real possibility, and serious constitutional questions would arise even if Congress purported to one day allow universal injunctions. See also United States v. Texas, 2023, Gorsuch J. concurring in judgment. I write separately to emphasize the majority's guidance regarding how courts should tailor remedies specific to the parties. Courts must not distort the rule that injunctive relief should be no more burdensome to the defendant than necessary to provide complete relief to the plaintiffs. Califano v. Yamasaki, 1979. Otherwise, they risk replicating the problems of universal injunctions under the guise of granting complete relief. As the court recognizes, the complete relief principle operates as a ceiling. In no circumstance can a court award relief beyond that necessary to redress the plaintiff's injuries. Complete relief is not a guarantee. It is the maximum a court can provide. This limitation follows from both Article 3 and traditional equitable practice. Because Article 3 limits courts to resolving specific cases and controversies, see U.S. Constitution, Article 3, Section 2, it requires that any remedy be tailored to redress the plaintiff's particular injury. Gill v. Whitford, 2018. And equitable remedies historically operated on a plaintiff-specific basis. Accordingly, any remedy must of course be limited to the inadequacy that produced the injury in fact that the plaintiff has established. Lewis v. Casey, 1996. Courts therefore err insofar as they treat complete relief as a mandate. Some judges have read our precedents to suggest that courts should provide plaintiffs whatever remedy is necessary to give them complete relief. See example. Mock v. Garland, 2023. Injunctions should be crafted to provide complete relief to the plaintiffs. Courts tailor their injunctions to provide complete relief to the parties, no less and no more. But that reading misunderstands the complete relief principle. This principle reflects the equitable rule that courts generally may administer complete relief between the parties. Ante at 851 emphasis deleted. It is an important aim of the law of remedies to put the plaintiff in her rightful position. S. Bray, multiple chancellors, Reforming the National Injunction, 2017, Bray. But to say that a court can award complete relief is not to say that it should do so. Ante 853 to 854. And in some circumstances, a court cannot award complete relief. As the court today affirms, any relief must fall within traditional limits on a court's equitable powers. See Ante 841 to 842, citing Grupo Mexicano de Desarrollo, S.A.V. Alliance Bond Fund, Inc. 1999, Payne v. Hook, 1869. Courts must ask whether the relief plaintiffs seek was traditionally accorded by courts of equity, Grupo Mexicano. And they must ensure that any injunctions comport with both the complete relief principle and other principles of equity. For example, courts may need to weigh considerations such as equity's concern with justice. Also for the defendant, in some cases, traditional equitable limits will require courts and plaintiffs to make do with less than complete relief. This court's decision in Frothingham v. Mellon, decided with Massachusetts v. Mellon, 1923, exemplifies this constraint. Appellant Frothingham sought to enjoin the execution of a federal appropriation act on the grounds that the act exceeded the government's authority and that its execution would improperly increase her tax burden. On a maximalist view of the complete relief principle, Frothingham would have been entitled to a national injunction had her claim been meritorious. After all, a prohibition on using her tax money for the statue would have been wholly ineffectual in remedying the injury caused by unlawful federal spending. Given the fungibility of money, the government would still have been free to execute the statute, so long as it labeled the underlying fund as coming from other taxpayers. A court thus would have needed to enjoin all spending under the statute to provide effective relief. But this court rejected Frothingham's request for such an injunction as beyond the preventive powers of a court of equity. Among other reasons, it emphasized that an individual taxpayer's interest in the monies of the Treasury was comparatively minute and indeterminable, and that the petitioner had not suffered any direct injury, but rather was suffering in some indefinite way in common with people generally. To be sure, what counts as complete relief can be a difficult question. Many plaintiffs argue that only sweeping relief can redress their injuries, and I do not dispute that there will be cases requiring an indivisible remedy that incidentally benefits third parties, such as injunctions barring public nuisances. Hawaii, Thomas J. Concurring. But such cases are by far the exception. An indivisible remedy is appropriate only when it would be all but impossible to devise relief that reaches only the plaintiffs. Such impossibility is a high bar. For example, the court today readily dispatches with the individual and associational respondents' position that they require a universal injunction, notwithstanding their argument that a plaintiff-specific injunction would be difficult to administer and would subject the association's members to the burden of having to identify and disclose to the government their membership. As the court recognizes, the prohibiting enforcement of the executive order against the child of an individual pregnant plaintiff is all that is required to give that plaintiff complete relief. Courts may not use the complete relief principle to revive the universal injunction. For good reason, the court today puts an end to the increasingly common practice of federal courts issuing universal injunctions. Hawaii, Thomas J. Concurring. The court also makes clear that the complete relief principle provides a ceiling on federal courts' authority, which must be applied alongside other principles of equity, and are holding that universal injunctions are impermissible. Lower courts should carefully heed this court's guidance and cabin their grants of injunctive relief in light of historical equitable limits. If they cannot do so, this court will continue to be duty-bound to intervene. Hawaii, Thomas J. Concurring.